Omar being used as the head of a spear that will tear apart the rule of law in Canada. How many other Omars are we going to see in the future? I'm actually very frightened when I see what happened. When no kind of process, due process of law is in place to protect this person, when citizenship has become a popularity contest. How many of us can lose our citizenship rights if someone gives a CBC poll and asks whether or not we should have rights as citizens? How many of us, how many children can lose their rights just because people don't like the looks of that child? We'll sign the Convention on the Rights of the Child, but we'll just apply it to certain people when those who are in power like that person. As I thought the rule of law meant that we were all supposed to be treated equally. When I started studying international law, I didn't expect that Canada would become a major violator of human rights. I thought we were international leaders, an example to others. We were known for having a culture of peace and respect. Now we're known for supporting torture, for violation of children's rights, and what we're experiencing now is a total disregard for the rule of law. The rule of law means that the rules that our society has decided upon are going to be applied equally to everyone. Several people have mentioned this phenomenon where Omar is being called a convicted terrorist. They seem to be able to do this with impunity. This is defamation. Omar has never been convicted by a legally constituted court. His so-called confession wouldn't stand up in any properly constituted court. There are many irregularities in this confession, many really weird things. For example, why did they want Omar to sign a statement saying that he voluntarily relinquishes his right for any forensic or scientific testing of any physical evidence, including but not limited to DNA evidence? Why are they so, if Omar was being held for valid reasons, why should they be concerned with suppressing evidence? But there are many other things like that. I don't think Omar will go for defamation. I think he's sick and tired of being caught up in legal procedures. It's been most of his life. I think he could be forgiven if he wants to maybe study literature, study other people, and leave his own problems behind. And I am not as concerned for Omar as I am for the rest of us, that somehow we've gotten on with our lives and we've allowed this to happen. What my article about was about what happened at the Supreme Court of Canada. And we have a very, very serious problem there. How did we lose the protection of the Supreme Court of Canada? Now, most people, I wrote that paper because most people don't have the education needed to read Supreme Court cases, or it's not easy for them. I actually would encourage you to do it. You can find any court cases on the internet now. Canadian Legal Information Institute, CANLII, C-A-N-L-I-I, and you will find the text of any case. And you can read the decisions about Omar Khadr if you have time. Most lawyers in Canada don't have time. They also don't have education in international human rights law. This is an area of interest that is treated as a sideline, and that might be one of the reasons why there hasn't been a larger upswelling of lawyers. I mean, what happened to Omar is so shocking. You would think that everyone in the legal profession and all educated citizens would just be shocked. When I look at the court system, I have to ask, what went wrong? The federal court and the Federal Court of Appeal both gave impeccably written reasons. All the Supreme Court of Canada had to do was refuse leave to appeal to those cases. Why it didn't, I don't know, because they refused leave to appeal to the majority of cases that people bring to the court. They should have left well enough alone. They were good decisions. Instead, what the Supreme Court of Canada chose to do was to undermine the very foundations of democracy and the rule of law. And that's what I find most disturbing. Apparently it did this at the behest of our Department of Justice. And this raises a number of questions about how the Department of Justice functions. Why was there public money? Why is the Department of Justice being used to come up with arguments that go against the will of Parliament, that go against conventions that have been signed by Canada and by the majority of nations internationally, so that it has become imperative law that everyone must follow? Why would our Department of Justice be working on such a thing? Why would they make arguments that violate the Charter of Rights and Freedoms, Canadian law, and international human rights? Why would they be working on that? That I don't understand. I've never worked there. I don't understand what goes on behind the scenes, and I don't understand what happened at the Supreme Court of Canada, because the Supreme Court of Canada is full of people that are very competent. They've written many competent decisions on the kinds of issues that came up in Omar Khadr's case, but the reasoning at the Supreme Court level contradicted some of their prior reasoning in some cases such as Hape and Salish. I won't go into the details of those here. People try to get what they can out of the Supreme Court case, and the Supreme Court did recognize that the frequent flyer program was improper. They didn't use the word torture, but it was improper, and people tried to emphasize that when they look at the Supreme Court decision. But what is really shocking and horrible is that the Supreme Court granted the executive in Canada unprecedented discretionary powers over foreign affairs. They did this using a number of strange little subterfuges. One of the main ones that they used was that they cited a case called Reference as to the Effect of the Exercise of the Royal Prerogative of Mercy on Deportation Proceedings. This was an old case from 1933. And that case cited Dicey, who is considered an expert on the English Constitution, as saying that prerogative power was, quote, the residue of discretionary or arbitrary authority which at any time is legally left in the hands of the Crown. Now, what's wrong with the Supreme Court of Canada citing this precedent when it didn't follow some of its own precedents that were more recent and quite correctly discussed the impact of international law? Well, to begin with, in 1933, Canada was not the independent state that it is today. Despite the Balfour Declaration in 1926 that said that Canada and the Dominions were equal to Britain within the British Empire, Canada was still legally a colony. There were still appeals of court cases to the Privy Council. There was no Canadian citizenship until 1947. There was no United Nations. There was no Charter of Rights and Freedoms. There was no Convention on the Rights of the Child or Convention Against Torture. It's only since World War II that equality rights have become very big and important. So one thing the court did is it didn't take into account the changes in Canada as a constitutional entity or as a state, that Canada is now a full-fledged state, or and even the concept of statehood has changed enormously since 1933, and certainly a lot more since 100 years ago. It didn't take any of that into account. But what's also wrong is their use of this quote from Dicey that was used in a completely different context. Now we're in the age of the internet. I was able to just look on the internet, and in no time flat, I found the entire text of Dicey's book. And just by doing a search and putting in a few pertinent phrases, I was able to come up with Dicey's opinion on prerogative power. And there are many quotes that suggest that Dicey would not have approved of this Supreme Court decision were he still alive. For example, Dicey pointed out that there is always a danger lest the use of the prerogative should supersede the supremacy of law. One of the important things about our British heritage, there have been a lot of unfortunate things. I've written a whole book about what was wrong, what went wrong with the British colonization of Indigenous peoples. However, there were some good things about the British Empire which explain some of its success. And one of the good things was that according to the British legal system, the monarch is always subject to the laws of the land. Who makes the laws of the land? It's the people. And we have now an administration that thinks that the law is what they think it should be. They have left aside both the Conservatives and the Liberals in their treating of Omar Khadr have moved away from the kind of principles that were very important when people were pushing for the expansion of democracy. And they've decided that I'm the king of the castle and you're the dirty rascal. That was never the theory of British monarchy, except perhaps for a time under some of the Stuarts, and they were put out of power. So I think what we have to learn from Omar's situation, it's not just to get justice for Omar Khadr, but it's to make sure that there are no more Omar Khadrs. What we're up against is very difficult. I think people tried just about everything they can think of. And really, in the end, whether we have a democracy has to do with individual decisions to follow the rule of law and to follow that. There cannot be a kind of society where our rights are discretionary, even though it's a law. You know, I like the color of your coat, so you can have what you want, but I don't like the way you're dressed. I don't think you should have the benefit of the law. I don't like your beard. You know, what is this? And why should Omar have to suffer this derogation of the principle of the rule of law? Thank you.
And so I think there's a bright side to this because it's otherwise a quite heavy topic. I'll just begin by conveying that Alnoor and I, in our contribution to this collection, decided that we would approach the Omar Khadr story by looking at a larger pattern that we think it belongs to. So we looked at a series of cases, and Maher Arar's case is one of them, and I'll tell you a bit about the others. But we think that it ought to be seen as part of a pattern of government conduct or response to certain cases, and that it ought to be contrasted with the approach in a couple of other cases that I'll mention, and we reflect on this difference. So over the course of this decade, as some of you may know, a number of Muslim or Arab Canadians found themselves in trouble abroad, or were, in a sense, the victims of Canada's own mistreatment of them abroad. So you know the Khadr story, you've heard the Arar story this evening. Another well-known story, and I won't be too detailed about these stories, is the story of Abu Hussein Abdul Razik, who is a Sudanese Canadian who traveled back to Sudan to see his ailing mother. And it's a very complex story, but due in large part to information provided to the Sudanese government by CSIS, by Canada. He was detained, held at length, tortured, then eventually released, and then more information was provided, and he went through, in essence, the whole thing all over again. He was at one point interrogated by CSIS agents in Sudan, which is really extraordinary. When he was eventually released, by the time he was released, because he was in Sudan much longer than he had planned to be, his passport had expired, and Canada wouldn't give him another passport. And what was really peculiar about this is that it resisted doing so, even though the RCMP and CSIS by then had cleared him of any suspicion of wrongdoing. So this is the story where the person was stuck in the embassy in the cartoon. So there's that story. There was also the three subjects of the Yakabuchi inquiry, if anyone remembers those. Those were 3 Arab Canadians traveling in Syria and Egypt, suffered detention and torture. There was an inquiry. The inquiry found that Canada was at least complicit in their torture, not directly responsible for it, but provided information that played a role. And lastly, there's the case of Suad Mohammed, who's the woman in Kenya, who was the subject of a kind of mistaken identity issue. They suspected her of having forged her own identity papers. They didn't detain her, but they placed her on bail, and they were sort of slow in helping her out and so forth. Anyhow, the point that we make is that if you look at these cases, what you see is Canada resisting assisting these Canadians abroad, or actively making the situation much worse. And at the end, when everything is said and done, Canada resists accountability altogether, with the exception of the Arar case, which is quite exceptional in a number of ways. We speculate that in that case, maybe Arar was compensated because the evidence there was so strong and so forth. But nevertheless, the pattern is a reluctance to take accountability. On the other hand, at the same time, there were a couple of cases involving Canadians who were not Arab or Muslim. Like, for example, Brenda Martin, who was a Canadian who traveled to Mexico and was kind of caught up in a Ponzi scheme and charged and convicted in Mexico of money laundering, I think was the offense. She was in custody there from 06 to 08, and during that period, Paul Martin, no relation, like the former Prime Minister, went to see her. Jason Kenney went to see her, and then ultimately Harper himself personally intervened with the Mexican president, and a few weeks later she was brought home, and 9 days later she was released. And she was found guilty. I mean, she was, okay. And then just one more case that we compare it to is the case of Robert Fowler, who was kidnapped in 2008 at a Canadian mine. Fowler was some kind of envoy, so he did have a quasi-governmental position. But Foreign Affairs worked tirelessly. One official we cite describes there being a kind of 24/7 rescue operation set up just to bring him back and one other aide to him. And so you have this kind of contrast. Now, there are counterexamples that it's important to point out. In 2006, Canada did quite a bit to bring back, in a hurry, all the Lebanese Canadians who were traveling in Lebanon in the summer that the war broke out between Israel and Hezbollah. And so that's an important counterexample. There are a few other instances where Canada has assisted people in the Arab world who are suffering persecution in this way, or in certain ways, so that we can see that there are those counterexamples. But nevertheless, we are left with this odd pattern. And so we suggest 3 possible readings, and I'll be very brief here. One reading is the good faith reading. You might say that in each of these cases I'm describing where Canada either didn't help or hindered the situation, there was good reason. I mean, there's an argument to be made in each of these cases for why Canada got involved and did what it did. And it's unfortunate that it hasn't come around and offered more compensation and support or accountability. There was the national security reading we suggest, that in the climate of fear following 9/11, we were just we were just more paranoid, and that maybe our paranoia, the government that is, has in large part to do with the fact that they have information that the rest of us don't. They're acting on secret information that makes, you know, the situation seem more critical than we can appreciate and so forth. And then we end with the skeptical reading, which suggests that maybe it was the case for both the Liberal and the Conservative governments that it was obvious that in the wake of 9/11, there was a great deal of, there was not a lot of sympathy, or you could say there was a great deal of animosity toward Arab and Muslim Canadians. And there was nothing to be gained politically to support these groups. And so there was an obvious reason to be silent about Khadr, about Abdul Razak, or to be indifferent to them, rather. So we have these three possibilities, and we end by suggesting that the point isn't which one of them is right. The point is that there's a lingering ambiguity about it. And we say that that ambiguity does enormous violence to the idea of citizenship in Canada. That if whether you are a member of these minorities or are not, all Canadians are left with a sense that maybe Canadian citizenship isn't universal. Maybe some groups are not fully Canadian. And that in turn does violence to our sense of Canada as an exemplary pluralistic society, a multicultural society, an example for the world at a time when many countries in the world are struggling with how to assimilate their minorities and so forth. So it is a complicated issue, but once again, I'm encouraged by how many people I see come out to talks like this, how many people are working so hard on behalf of all of the people I've talked about, all the stories I mentioned. They're not alone. People in this room who are concerned about these issues are not alone. We make up a good portion of the Canadian population, and I do think that there's hope. Thanks so much.
Omar pleading extraordinarily guilty is a betrayal of our commonality. O Canada, culty, multi, blood guilty. Guilty of our loyalty, of turning our backs to faulty officiality, of maintaining our plutocratic viceroyalty. Is Omar pleading extraordinary guilty, collective child cruelty, concocted by eons of efforality, emboldened with a pornographic spirituality? Pleading extraordinarily guilty, is it just a temporal novelty, this racism on the Muslim polity that you show with your similitude? So, there is a fourth way of looking at the response, the Canadian response to Omar Khadr, and we didn't quite address in our article that I'd like to offer up here, and it's the activist reading. And many of us in this room, I think, are activists. I mean, you're out here. I think that you are, aren't you? Yeah, yeah. Give yourselves a hand, yeah. You know, it was, what's her name? Naomi Wolf, I think, made a speech after, I think in 2003, talking, and she wrote a book about fascism coming to America and was paralleling how the 1930s and 1920s in Germany and the things that were going on there are exactly parallel to what's going on today in North America. And we know this with Obama signing the NAA Act and our own rendition cases that we have. So there is this fourth reading, this activist reading. So it's skeptical of the good faith reading that the politicians know what they're doing and all of that. And it tries to make sense of a deeper political motivations in the national security reading. I mean, that question of why was that Robert Fisk and lots of others pointed out that we could never ask as journalists or whoever. So they view the good faith reading from the presumption that all governments lie. And I.F. Stone is a journalist who I think quoted that, and Howard Zinn also picked up on that all governments lie. So even when we hear their mouths, we need to understand what is really that they're saying. So activist reading views the national security reading as this fear tactic leading society towards accepting the path of the intensification of executive power that Grace talked about. this grabbing of power that all governments do. I mean, the Conservatives have grabbed so much power, but I bet you when we kick them out and the Liberals come in, they're not going to rescind any of those. I mean, we went through that with the Obama change, remember, right? I mean, he's made it worse, I think, in many ways. So they want to, the activists, I think, are always looking for what is underneath. That is, I mean, okay, so we say that the country is split, right? 50% of the people are kind of like, okay, let's bring Omar back, and 50% are not. But when we see that Romeo Dallaire's petition has 30,000 now, that's been going on for a couple of months. It's got 30,000 out of 15 million, so the goal should be to maybe get it to 15 million, since half the country and other polls say that they want Omar back. So the activist interpretation is not a marginalized reading, I don't think. I think it expresses itself in diverse ways. Many contributions in the book, for example, are activists' readings. There were a couple that were, I think, looking at multiculturalism as a failure, or one at least, I think, in the book. But for the most part, the book, I think, are scholars who take on this activist approach. And we have seen lots of examples in film and radio, music, performance art, some of which is included in the book. There's lots more on YouTube. There are organizations like Houses Not Bombs. Lawyers' Rights Watch is another one I would put into this activist group. The People's Commission Network, if you look them up, they have a series of all of the security certificates that have been issued by Canada, their biographies, how to get a hold of these people, what they're up to now, what they're saying. The good faith and the national security readings demand justice and nonviolent direct action, implementation of transformative solutions. Houses Not Bombs works towards demonstrating the very clear links between militarism and poverty, as well as connections to sexism, racism, homophobia, classism, which are all related forms of discrimination. So when we talk about this, we need to understand the intersectionality of this, and I think that we do here in this room understand that. And they aim to facilitate alliances and information sharing and coordinate strategies with oppressed people, such as Indigenous people. And I'm sad that Kat wasn't able to stay, but it was nice to have her here and acknowledge where we are. I think I will just end there with remembering Kat and remembering why we're all here. I mean, and what that injustice is all about as well, that when we start unpacking all of these other injustices that are going on. Thank you.
Thank you very much. There are a couple of things I just wanted to clarify. One was Maher Arar mentioned that the man that was killed, the American soldier who was killed in the compound in Afghanistan, and Omar Khadr was charged with his murder and convicted of it. That he was actually, he's always talked about as a medic, but he was actually a Delta Force soldier, and it's really interesting to see how the kind of media representation of this man as a medic transforms how we think about him. But it is important to recall that he was acting as a Delta Force soldier. This was a kind of a combat zone, even though the language and Omar Khadr himself was not considered to be a soldier. He was considered to be an enemy combatant, but I just wanted to clarify that. And the other thing is that when we talk about Omar Khadr, it's such a long story, it's 10 years. So we do have to recall that when the Liberal government was in power, they did everything, they appealed all of the judgments that came out in favor of Omar Khadr. So the Liberal government really was did a lot of significant work in maintaining his presence and refusing to not appeal some of the judgments. So that's important to say that since 2007, when the charges were laid, et cetera,
and various things happened. The Canadian Bar Association came out very strongly against him, and other people joined the Amnesty International and other organizations that have been supporting Omar Khadr since 2002. But in 2007, that's when Stéphane Dion and Paul Martin and later Ignatieff and Bob Ray joined the New Democrats in condemning Omar Khadr's treatment. So since 2007, all of the parties except for the governing party have in fact criticized the ongoing exile of Omar Khadr in Guantanamo. I just wanted